The year is 1950, and in a letter, Prime Minister Nehru writes to a few chief ministers saying, if the constitution itself comes in our way, then surely it is time to change that constitution. Wait a second, you guys just drafted it. What is going on? Hello and welcome. My name is Priya Mirza, and this podcast is the longest constitution, and we talk about the constitution. We are carrying on with our investigation of the faded fundamental right to property, that is Article 31, which was repealed in 1978. The poor thing had a really short life, but the question is why? We are also looking at how Twitter and other social media platforms affect our digital rights, and finally, what is in the interests of public order. And that's one of the reasonable restrictions which clamp our right to freedom of expression. So let's start with that one. Bachao, bachao, Hindi bachao. Yeah, it's the 1950s and a communal war is raging in Punjab over Hindi. And there is a Save Hindi agitation between the supporters for Hindi and the Akali Dal. So remember, I asked you in the previous episode, what did the members of the Constituent Assembly fight and argue over the most while drafting our constitution? And no, it wasn't cow slaughter or prohibition on alcohol, but language, zuban, bhasha, jo aate hi aati hai, ji janab. Yeah, so in the Constituent Assembly, the pressing questions were, what should the official language of the union be? And on what basis should the states be organized? And the politics over language is pretty much at the heart of the constitution of making this great nation and each one of us. So consider this as a little appetizer of what we will be doing very soon. Anyway, what was happening in Punjab in the 1950s? Yeah, language was an explosive matter, and there were lots of articles in papers about the Save Hindi agitation. And what did the government do? The state government issued an order to prohibit the printing or publication in any form related to this language war for a period of 2 months. That's right, for 2 months, no publications on saving Hindi. And if you remember, this is a form of prior restraint and was challenged in court. Our second story today carries on with where we stopped previously, and let's get on with Donald Trump. So what's common between Sanjay Hegde and Donald Trump, who, by the way, said, I know words. I know the best words. I'm sure he does. And like Hegde, Trump's account was also suspended by Twitter, which isn't a question of Indian constitutional law, but the question is, how does one hold Twitter accountable for structuring online speech? And when Hegde filed a public writ challenging his account suspension as a violation of his fundamental right to expression, the court's answer was, live without Twitter. Before adding, dude, switch to Instagram. Not in so many words though. Quite funny, but evades the crucial question. How does one achieve a balance between the rights of an individual, the sovereignty of the state, and prevention of illegal activities within India? So now we need to do some unpacking and unraveling. In 2020, after Hegde's case, the Ministry of Electronics and Information Technology notified the Intermediary Guidelines and Digital Media Ethics Code Rules 2021. Quite a mouthful. And these rules apply to WhatsApp, Instagram, Facebook, of course, but also OTTs like Netflix, Amazon, Disney, and Hotstar, as well as digital news media, all those things which keep us very, very occupied. Now, intermediaries basically receive, store, and transmit information which they've received. So if they aren't creating this content, why should they be liable? So going by the IT Act and these new rules, these intermediaries are protected by the safe harbor principle. Now, these rules are quite extensive, but I'm going to underline just 3. So the first, safe harbor principle, which means that intermediaries will not be responsible for illegal content such as child pornography. But here comes the catch. If they pull it down within 36 hours, which leads to point number 2. Because of the scale of the data being uploaded, intermediaries employ AI bots, that's artificial intelligent bots, to do this, which comes to point number 3. So the power to decide the limits of freedom of speech and expression is in the hands of private corporations and, what's worse, artificial intelligence. There's a lot more too, such as the fact that intermediaries can store your data for up to 180 days, even after you delete your account. And lastly, are obliged to ask for personal data like your phone number, which is voluntary, by the way. But we know of things which started off voluntarily but became mandatory, don't we? Okay, now what was Nehru talking about changing the constitution? And that puts us back in our investigation of the history of the abolished fundamental right to property. So put on those boots because we have some digging to do. Now, we remember that in the Kameshwar Singh Maharaja of Darbhanga case, the court held that the government's law on land acquisition was, and I quote, unconstitutional law and hence illegal. So the court basically said that if you don't give these property owners compensation, then what sort of rights do they have over their property? Plus, the courts basically did what they were constitutionally mandated to do, which is uphold fundamental rights. But in the case of property rights, this pitted the constitution directly against the government's stated policy. And the court judgment was a bombshell and left Congress leaders really shocked. Ab kya kare type. In the meanwhile, this and other land reform related decisions were appealed before the Supreme Court. But before the court could give its decision, the Constitution was amended. And that is the Constitution First Amendment Act 1951. Now, we have done a part of this in a previous episode, so run along and listen to that one too. But fundamentally, the first amended 3 fundamental rights, 15, 19, and 31, and inserted Articles 31A and 31B into the right of property and introduced the 9th schedule in the Constitution. Hold on, it's coming to an end. And allowed Harry Potter and the Chamber of Secrets into our Constitution. What? Yeah, now hold on. Meanwhile, what happened in the issue of the Hindi agitation in Virendra versus State of Punjab 1957? The court upheld the prohibition on publishing because, to quote, quite conceivably, this agitation might at any time assume a nasty communal turn and flare up into a communal frenzy and factitious fights disturbing the public order of the state. So the possibility of disorder allowed the government to pre-censor political material without any meaningful judicial scrutiny, simply by citing public order under Article 19. So let's wrap things up. The First Amendment amended Article 31 and placed all sorts of property like Jagir, estates, inams, or munafi beyond the reach of compensation. And yes, I did mention Harry Potter. The amendment also introduced the 9th schedule. Now pay attention, you wizards, this is important. The 9th schedule was a bit like the invisibility cloak. Do you remember that? And if you don't, that's okay too. The 9th schedule is a special compartment in the Constitution in which laws placed within it would be invisible to the Supreme Court, basically beyond the court's reach. And this tilted the balance of power in favor of Parliament, which could now protect laws from being challenged in court. Cool invention, but it depends who's using it, Harry Potter or Voldemort. And what sort of laws are put in it right away? Yep. 13 laws, including the Bihar Land Reform Act. So today's takeaways are, in the interests of public order, a newspaper was prohibited from carrying articles on a particular issue, and this was upheld by the court. Land reforms in the 1950s threw up a heated contest between Parliament and judiciary, landowners and the Congress, and this was just round 1, by the way. Lastly, the 2021 rules limit free speech and the right to privacy, as well as placing burdensome obligations upon intermediaries, digital news, and OTT platforms. That's all for today, gentle listeners. If you have questions or comments, please send them in via email. That's thelongestconstitution@gmail.com. You can also rate my podcast at Spotify and drop a review at Apple Podcasts, and can also reach out to me on Twitter, where I am at FundamentallyP, or on Instagram. the longest constitution. Until next time, this is me, Priya Mirza, signing out.